Welcome to the Aging with Options show. I'm Chris McCutcheon. Thank you for joining us on the program today. The Aging with Options show is all about seniors and for seniors, as well as their loved ones who care for seniors right here in the Louisville area. Every week at this time, we're pleased to bring you interesting and informative topics for our senior community. Through the sponsorship of BrightStar Care with the contributions of our expert guests, we cover a variety of subjects on the show, from innovative products and services for seniors, senior living, long-term care, aging in place, local senior events, just to name a few. Aging today can be very intimidating for seniors for a number of reasons, not the least of which, of course, is the growing number of legal issues they face. Elder law attorneys specialize in assisting seniors and their family members as they plan for retirement, serious illness, end-of-life issues, nursing home placement, Medicaid counseling, guardianship, and many other topics which confront all of us as we age. A good, competent, and helpful elder law attorney should be an essential member of the care team that every family with senior loved ones should have in place. It's an honor once again to be joined in the studio today by elder law attorneys Bernie and Rhoda Fowler. Their firm is Kentucky Elder Law. Since Bernie started the practice 10 years ago, Kentucky Elder Law has grown to be the largest law firm in Kentucky. Bernie and Rhoda, thank you again for joining us here on the Aging with Options show. It's good to have you guys as return guests on the show. Thank you for being here again.
Well,
thank you, Chris.
We're happy to be here with the largest elder law firm in Kentucky, not the largest law firm.
Largest elder law firm in Kentucky, absolutely, since starting it 10 years ago. So, guys, again, thank you very much for joining us again. It's a pleasure to have you here. And last time we got together, we talked about a number of topics, but Rhoda, we talked about the fact that Bernie started his legal career a little bit more recently and began right away working in the area of elder law and started the firm Kentucky Elder Law. But Rhoda, you've been an attorney since 1978, is that right?
Yes.
Okay. And you joined Bernie's firm, the firm that he started, Kentucky Elder Law, around 2007.
Correct.
Right? Well, tell us, we asked Bernie this question last time, I'll ask you this question this time. What attracted you to expand your career in law into the area of elder law?
I wanted to help people. I've devoted my life to helping people. Past careers were being in a Peace Corps kind of program for a year, then being a high school biology teacher, and then being an attorney helping people who were vastly injured by medical negligence, such as brain damage baby cases. All of that was very stressful, and I reached a point where I thought it would be beneficial for me to have somewhat less stress in my life. Bernie invited me to join him in his firm, and there we've been ever since.
Very, very well. So many of our listeners have family members, perhaps that are attorneys, perhaps they have a trusted relationship with an attorney that they've used in the past for other purposes. Tell us why it's important for seniors to seek out an attorney that specializes in elder law, because they may have an attorney friend that could certainly help them with some of these same issues. Why should they be seeking out an elder law attorney?
If the attorney is not a specialist in elder law, inadvertently the attorney could do things that are harmful rather than helpful. Since over half of all seniors, close to 70% of them, will spend some time in a nursing home, not necessarily long-term, but for rehab, but for many long-term, with the outrageous costs, private pay being over $100,000 a year in the metropolitan Louisville area. People need to plan for the potential that they will need Medicaid, and things that other lawyers might do thinking they were looking out for best interests could cause huge problems and penalties for family members down the road.
Great, good advice. So tell us, Bernie, if you would, what are some triggers that family members should look for that tell them it's the right time for their family to seek out an elder law attorney?
Well, first thing, our clients are mostly in their 70s, 80s, and 90s. If you see any type of a slippage with a parent, or just that they're getting up in years, they want to at least get their legal documents in the form that are used, because most attorneys, they write powers of attorney and living wills, things like that, and they get put in the drawer because the people are healthy. And a lot of the documents are not that good. They're just not up to date. And our documents are used all the time because we're dealing with an age group where where they get used. So as you get up in years, it's worth looking at. Certainly if you start to actually see a problem, and often people don't come to us till mom is already in the nursing home, and mom's been going downhill for 7 or 8 years, and they finally get around to us. Sooner works better than later. The sooner they come, the better, and at times they come to us when the parent is no longer competent. They're in the later stages of Alzheimer's. Early stage of Alzheimer's is still legally competent for documents in most cases, but in the late stages it's not. And then we may need legal documents to do certain things, and we can't get them, and so we can't do any type of work because we have no authority.
In addition, if somebody has sizable assets that they want to protect, the sooner they come to us, the better. So if somebody is 70 or 72 years old and perfectly healthy, but with sizable assets, we can give them information and help them to start to protect assets in a way that will keep them protected in the future.
Okay. Now, Bernie, you mentioned oftentimes folks will come to you once mom and dad are already in the nursing home. Is it too late at that point?
No, it is not too late, but we have fewer tools available to us. We will generally meet with the people. Often we will update a power of attorney because usually what they have is either old or obsolete or not at all. Get them a living will and healthcare surrogate that are really somewhat different from what's out there. We take another look at their wills. Typically they have wills where they leave everything, husband, wife, leave everything to each other. That made sense for the last 50 or 60 years. But if dad's in the nursing home and mom is home, and mom dies first, which certainly happens, leaving everything to dad who's in the nursing home may not be a good idea. So we look at all of these things. So they should certainly come to us in that situation. In fact, that's typical. But planning sooner just has more options.
So ideal situation is mom and dad are still healthy?
Yeah, that's the ideal situation, and we do see that occasionally. But typically people wait a long time before they bite the bullet.
I gotcha. I certainly understand that. Let's shift gears just a bit. Let's approach the topic of advanced directives.
Sure.
Rhoda, tell us what are advanced directives? What does that involve? We hear that term sometimes. What is that? What does that mean? And who needs advanced directives?
Everybody over the age of 18 needs advanced directives, just like everybody over the age of 18 needs a power of attorney, a healthcare surrogate, and a will. But advanced directives is where somebody has in writing telling their family what their desires are when they are terminally ill with no chance of survival. That is called a living will. The living will should look like the Kentucky Form Living Will because doctors and nurses have told us if it looks different than the standard form, they'll send it to the legal department to determine the validity and thus delay the use of it. The living will deals with somebody approaching death and answers 3 questions. When they're terminally ill with no chance of survival, do they want life supports? When they're terminally ill with no chance of survival, do they want someone to implant a feeding tube into their stomach? And when they pass away, do they want to donate their body to the medical school? DNR, do not resuscitate, is often mixed up with a living will. A DNR is when someone has literally died. Their heart has stopped beating. Should they be resuscitated? DNR applies to ambulances if it's done on the proper form for ambulances. DNR also applies at the hospital. Living will does not apply to ambulance workers because EMS workers' job in the absence of a DNR is to get you to the hospital so that the medical people can try to revive you. Now, I have a living will. I don't want to be kept on life supports when I have no chance of survival when I'm brain dead. I do not have a DNR. If I had a heart attack and my heart stopped beating, I would very much want people to try to revive me.
Completely different things.
Yes.
Yeah.
So they both deal with death coming from different approaches.
One simple way to think about it is a living will is used when you are alive, and a DNR is used when you're dead. So the living will, you're alive, and the question is, do we let you die? And the DNR, you're dead, and the question is, do we revive you again?
Very important distinction. Kentucky Elder Law helps seniors and their families prepare for the legal issues they will encounter. Bernie and Rhoda Fowler, elder law attorneys, are my guests on the Aging with Options show. We'll be back with much more right after this break, brought to you by BrightStar Care. You're listening to Aging with Options on 970 WGTK.